One of the provincial colleges has estimated that over 80% of college complaints arise from communication issues. Patients and their families will often make a college complaint when they are looking for information or answers that were available to them from their treating physician. As provincial council, we know that these conversations are difficult. We know that these conversations are often unpleasant, especially if there's been a bad outcome. But we also know that physicians who make communication a priority will substantially reduce their chances of getting a college complaint.
One of the most basic factors in charting is handwriting legibility. Simply put, if it can't be read, you're wasting your own time, you're wasting people who have the opportunity to review the charts time, and you're putting patient safety at risk. The most graphic example of that I have is a QAC review process that I participated in with a senior physician whose charts were voluminous, they were disorganized, and his handwriting was very difficult. One of the QAC members asked him, "Doctor, I'm having difficulty with this note. Can you read it for me?" And he said to her, after looking at it, we puzzled over it, and he said, "Well, you know, there are only two people that can read my notes, me and God, and sometimes not me." Now, that's not really the response that a physician should be giving. It's not helpful, and quite frankly, it's not the standard of the profession. Your charting is not just for you. Your charting is for everybody that comes in contact with it, and it's also a patient safety issue because decisions are made based on the quality of your charting.
I had a physician once who had done a very, very clever thing in his medical records. He was a surgeon, and for each informed consent discussion that he had with a patient, he had an acronym that would set out for each letter the complications that the patient had been told were possible to occur as known complications with the surgery. When a patient had one of these complications occur, she was not satisfied and believed that she had never been told that this could happen to her, so she sued. At the discoveries, the doctor explained to the plaintiff's lawyer what each of the letters in his acronym stood for. And when he got to the fifth letter and it stood for the very complication that she had suffered, the plaintiff's lawyer knew that indeed his client had received the information before the surgery. She had consented to it on the basis that that complication could occur. And on the break, the plaintiff's lawyer told me that he was prepared to have the action dropped. So the doctor had actually saved himself with that very short step of putting in a 5-letter acronym into his medical records.
Well, in a case where we had an emergency physician who was responsible for a patient being admitted into the emerge, had to be transferred to the floor, but there was inevitably a delay of a couple of days in transferring the patient to the floor. What happened in those circumstances is that there was later a college complaint. The college found that the emerge physician in those circumstances took reasonable efforts to try to make sure that the patient was cared for during the delay, as well as speaking to the physician on the floor and taking reasonable and appropriate steps to make sure that the patient was appropriately cared for. But probably more importantly, what the college found and appreciated in these circumstances was that the emerge physician took reasonable efforts to document all of his attempts to make sure that the patient was cared for. So documented the conversations he had with the patient, with the physician on the floor, as well as the efforts that he took to make sure that the patient was cared for.
All right, so you'll now have heard lots of advice regarding your notes. Some of my colleagues will have told you that they need to be clear, they need to be legible, they need to be contemporaneous, they need to be thorough. There's one more thing that your notes need to be, and that is originals. Every so often, God forbid, you'll receive a complaint or you'll receive notice of an action, and it becomes very difficult to resist the urge when you review your notes relating to that patient to not add something or to remember something which might change things, and it becomes very difficult not to go in and decide that you're going to fix your note. And I'm here to urge you to resist that impulse, because that can turn what is a very simple problem into a very complicated problem. A note change can sometimes be appropriate, but it absolutely has to be crystal clear that you've gone into your note and you've added an addendum afterwards. And in doing so, you're going to want to time when you've done it, and you're going to want to add the date to this addendum so that the reader has no mistaken impression as to what went on. It has to be very clear that this is something that you've added afterwards. And that can be perfectly appropriate. In fact, that can clear up certain things. We've had situations where the patient has had an encounter and the patient has called the physician the day after and added something, and the physician has gone back into his records and made that addendum, which makes his original notes a lot clearer. That's perfectly fine. But when you receive notice of an action or you receive notice of a complaint, that note, that record becomes off limits, and it's absolutely critical that no changes be made to it.
Sometimes being humble and knowing how to apologize saves a lot of trouble. I have the situation with a physician, a specialist. He was having a bad day. It was a long day, and the very last patient was a patient who came with 2 briefcases full of documents to document really how that patient was disabled and how the physician, the specialist, should sign a disability form. After an examination, the physician was not going to agree with the patient. Obviously, the patient was not pleased, and there was a discussion. And after an animated discussion, the physician just lost it and decided to ask, in a tone of voice that was not very constructive, ask the patient to leave his office. He recognized the next day that maybe that was not the right thing to have done. And he picked up the phoned the patient and apologized for the outburst of the day before. Now, the patient was not the type of patient who would be satisfied with an apology. He was aggressive to start with. And despite the apology, there was a complaint to the college. But when the college learned about the apology and saw that the physician, despite having done the wrong thing the night of the appointment, had done the right thing by apologizing the next day, the college dismissed the complaint.
First of all, what we deal with most often, and what most physicians probably think we deal with most often, is their actual care provided to the patient. But what we also see are cases where there are allegations that the plan for care or the transfer of care to other healthcare providers was negligent. I distinctly remember a case, it's a number of years ago, but it stays in my mind because the physician's note was very detailed, most detailed I'd seen. And I remember saying to the physician when I met him, if old notes were like this, you'd put me out of business. And he laughed and he said, well, don't worry. This was a particularly detailed note because I was going on holidays. I knew that I had to transfer the information. I wanted it written down. It was interesting because he had charted his key observations about the patient, had charted what his plan of care was in a detailed manner, and had charted the tests that he thought had to be undertaken in accordance with that plan of care. Took his chart notes from him, copied them, sent them over to plaintiff's counsel, talked to plaintiff's counsel a couple of days later. Plaintiff's counsel said, I'm going to leave your doctor in the action, but I can tell you I'm not going to be focusing on him. My focus just shifted to some of the other defendants. The good news story for that physician, he got out of the action very early because his chart note was so clear, plaintiff's counsel knew what he'd say in discovery. Not so good for the other doctors because the evidence was that that information that our physician had charted had been verbally transferred. And unfortunately, the other physicians weren't as diligent in their follow-through on the plan of care as we would have liked them to have been. But for that fellow who did the good chart note, that saved him. Take the time to communicate. And it never hurts to communicate twice. Eye to the person that you're transferring over to, or ear to ear if you're on the phone. But then back it up with a detailed chart note because it's what you think about the case at the time, it's what you've communicated at the time, and for that busy professional who you're talking to, eye to eye or ear to ear, and they're half distracted by their other 15 cases, they can then go back to your detailed chart note and say, aha, yes, good, A, B, C, done.
So I had a client who was a resident at the time, and she was a resident in the emergency department when a patient came in with a number of signs and symptoms, including a very high fever. Investigations were done, but they were unable to diagnose a problem at that time. The resident provided very clear instructions on discharge that included coming back to the emergency room if the patient found that her fever persisted for more than 24 hours. She had made a very clear note of that in the discharge instructions section of the emergency document, and that little note ended up saving her a lot of trouble. Unfortunately for the patient, she did not come back to the emergency room for another week, at which time she was in a coma and she ended up having viral encephalitis with a very poor outcome. An action was started against the resident, and the notes were so clear that we were able to explain to plaintiff's counsel that in looking at the notes, the instructions said specifically to return to the emergency room if the fever persisted, and the patient had not followed those instructions. Because of that note, the plaintiff's counsel decided to recommend against proceeding with the claim.